I require any and all exhibits or any visual aids, any PowerPoint presentations to be used during opening statements to be shown to the other side prior to the opening statements. I also require all exhibits to be marked for identification and shown to the other side, with the exception of something that you intend to use for surprise. And under those circumstances, I may make the ruling if there's an objection at the time the attorney uses the item. As to animation or technology of that sort, I think it would really depend upon the particular animation. I mean, certainly it has to accurately reflect what it's supposed to depict. I think obviously objections by the other side have to be entertained, but I certainly think it may be able to be shown to the jury as a visual aid. Whether it would be admitted into evidence is a different issue.
Exactly.
I follow pretty much the same procedures as Judge Madden, but I would like to say that I think that PowerPoint presentations often employ very inflammatory captions, and for that reason, I think it's particularly important that the other side have the opportunity to see them so that they can be redacted without disrupting the flow of the opening or the questioning of the witness. On a case not so long ago, I also had a battle royal over a picture of a lung that was bright red, and it was considered very prejudicial by the defendant. So it's really better to be able to rule on those kinds of objections, I think, before the technology is used.
Yeah.
Did you admit it, Your Honor?
Pardon?
Did you admit it?
I did.
That all goes to that discretionary call of whether or not the probative value outweighs any prejudicial effect, and you have to look at each one. No, it's not an example.
I mean, we talk about aids to the jury, aids to the court, but I mean, I follow a similar procedure what is discussed by the other judges. First, with regard to exhibits, the exhibits must be marked and exchanged before the trial. As far as PowerPoint presentations or other technology during the opening statement, I urge counsel to exchange it before the opening statement, not a day or two before, but perhaps the morning of the opening statement. I encourage counsel to do that, telling counsel that it's not worth the risk of having it excluded totally just to give up a surprise element. It's better to share it a little early so that counsel can make an objection to exclude some of the inflammatory captions or some prejudicial portrayal of a participant in the trial, and have it corrected rather than have the judge shut it down in the middle of the presentation